So you're interested in making a will. Great, good on you. Most people don't even make a plan. Something like 53% of Americans never do any estate planning whatsoever. So if you are in the 47% of people that do estate planning, good for you. I'm here today to explain to you how to make a will. Now, the act of creating a will is a privilege. Not every country allows you to make a will. Hard to believe, isn't it? But in some countries, most notably France, they have a system of forced heirship where you cannot make a will. Your estate is going to pass according to the law. When that was innovated, it was actually pretty progressive to be able to make a will. And so in the United States, it's pretty progressive comparatively to France that you can make a will and you can leave your estate to whomever you want. So here's the most important thing about a will. It has to be in writing. Can't leave an oral will. A will must be in writing in order to be a valid will. So if you're creating your will right now, start by writing at the very top of it, last will and testament. All right, just give your document a title. Then you're gonna use the following statement to start your will, to start your wishes. I, name of county and state, declare that this is my last will and testament, hereby revoking all prior wills and codicils. So what you're doing here is you're identifying yourself, of course, and you're identifying the place where that will should probably be admitted to probate. And that's going to be the city or county where you reside. Then you're going to go ahead and say what you're doing. You're making a prequatory statement here saying you're creating a will, and this is meant to be your last will and testament. You're revoking any prior wills. After you write out the prequatory statement, next you're going to write I appoint name as the executor of my will. You can also appoint alternates, and it's a good idea to have an alternate. If first executor is not available, then I appoint so-and-so to serve as the alternate executor of my will, and etc., so on and so forth. Okay, then you're going to go on to state your wishes, going to come back to that in a minute, and then you're going to go ahead and sign and date that document. Now, if you're doing this entirely in your own handwriting, that's called a holographic will. A holographic will that is 100%, not 98%, 100% in the testator's handwriting is going to be a valid will in Virginia. However, you probably shouldn't rely on a holographic will. It is terrible discovering that you have a holographic will. It's, as an attorney, it's like you're trying to make our lives easier, but you just made our life a whole heck of a lot harder than it had to be because you created a holographic will. You didn't go to the formality of having that thing signed in the presence of witnesses and a notary. And so after you finish writing out all your wishes and you sign it, you should be signing it in the presence of two non-blood relatives. That's important. They shouldn't be your blood relatives. They shouldn't be interested parties to the will. They should be neutral people. And in Virginia, there's a presence requirement. You can't sign it and then take it down the street and say, oh, hey, I signed this thing. Will you please also add your signature as a witness? No. The witness has to watch you sign the will in their presence and vice versa. You're also going to get that will signed in the presence of a notary. The notary is their function is to certify your identity, and you are the person that signed this document. And so that's also really important. And if you have all the written requirements for a will and you signed it in the presence of two non-blood relative witnesses and a notary, and you have the correct self-proving affidavit language, then that is going to be a valid will that is going to need no further proof to be admitted to probate as your last will and testament, right? The whole thing about having two non-blood relatives witness and a notary acknowledge your signature to your last will and testament is that it makes the will self-proving. Again, it has to have that self-proving affidavit language in it as well, otherwise clerks give us a hard time. But those are the fundamental ingredients of creating a will in Virginia. And the effect of the self-proving affidavit is really nice, that we don't have to go ahead and get a further deposition of that witness to your will. That's what it's called. A deposition of witness to will form is something that we oftentimes will have to go out and acquire from the person who witnessed the will. Now you can see how that might create some problems. If we can't locate either of the witnesses, that's going to be a problem. We're going to have a much harder time getting that will admitted to probate, and your probate just got thousands of dollars more expensive. The point of this exercise is to save people the heartache of these difficulties. So if you don't follow all of these steps to make a valid self-proving will, extra steps are going to be required and rigmarole is going to entail. All right. Now, let's go back to the distribution language that you're going to use in your will. Your will can make all kinds of different benefits for people. There's different types of benefits. There's pecuniary bequest, for instance. If you leave someone $5,000, that's a pecuniary bequest. If you make a specific bequest, that might be like, I'm leaving my nephew my car, 2024 Toyota, let's give you a Camry. There can be all kinds of different things like terminable interests. A life estate to a piece of property might go in a will, or you could do any number of other things. A specific bank account to a specific person, depends on what your property is. But here's the one thing that you need to have in your distribution language. You need to have a clause that says, I give the rest, remainder, and residue of my estate, and then in the following manner, or to a specific person, or however you're going to do it. And it's important to use clear and unambiguous language in making your distribution. And that's why attorneys are really good people for creating wills, because we go to logical reasoning school, also known as law school. We get into law school based on our innate ability to do logical reasoning. So crafting clear and unambiguous language is what we do, and good attorneys achieve. That's also why you should hire a professional to do your estate, because messing up that language leads to so much heartache for people that it's just not worth putting in the hands of someone inexperienced. And if you're drafting your own will, then that's going to be the case, I'm guessing. It's kind of like I analogize to an electrician. Are you going to wire up your own home? Maybe you could figure out how to do it on YouTube. Maybe you could figure it out how to do it by listening and reading and DIYing. But the odds, even if they're favorable, the consequences of messing up are catastrophic, right? If you miswire your home and you have a fire, there's going to be loss of life and property. Creating a will, it's the same thing. There's the potential for loss of property, and if the movies are to be believed, life. So it's not something that you really want to do yourself, but you're watching this video, and best of luck to you. So then, after you create your will, it's important to review what you've done regularly so that the will still meets your needs and wishes. I tell people to pick a day every year where you're going to take a look at your estate documents. It could be your birthday, it could be a child's birthday, it could be an anniversary, some day that you're going to remember, oh yeah, this is also the day that I pull out my estate plan. And yearly might seem like too often. If you can recall what you did very, very clearly because you just did it, okay, that's your own assessment of your own capabilities. But knowing that you have one day every year where you're supposed to look at your estate plan is going to serve you if you make it a habit. All right, now, I'm not your attorney, and you haven't engaged me to prepare any legal documents for you, and this video does not create an attorney-client relationship between us. With that being said, all the best. Reach out if you need any help. Thanks.